The billing alert appeared on my screen at 11:47 p.m. on a Tuesday, flagging an ethics violation complaint that didn't exist. I stared at the notification from our case management system. Client billing irregularities detected. Partnership ethics review initiated. My name was listed as the subject attorney. The timestamp showed the complaint was filed 3 hours ago during a client dinner I'd attended with 2 witnesses. My name is Alexander Ashworth. I'm 42 years old, a junior partner specializing in corporate litigation at one of Raleigh's fastest-growing law practices. I'd built my reputation on meticulous case preparation and ethical billing practices. This alert made no sense. I clicked through the system logs. Someone had accessed my client files using administrative credentials at 8:23 p.m. The IP address traced to our downtown office, but I'd been at Sullivan Steakhouse with the Henderson Industries legal team until after 10. My keycard hadn't been used to enter the building. The complaint alleged I'd been double billing clients for document review services. Specific dates were listed: March 15th, April 3rd, May 22nd. I pulled up my calendar for those dates. Each one corresponded to major case deadlines when I'd worked late preparing motions and discovery responses. Someone had manufactured a billing fraud using my login credentials. I scrolled through the attached documentation. Fabricated time entry showed me billing Henderson Industries and Coastal Development for identical document review hours on the same dates. The entries looked authentic, complete with case numbers and detailed descriptions of work performed. But I'd never submitted these entries. The system showed the complaint was filed by an anonymous partnership member. Internal ethics violations triggered automatic review by the firm's disciplinary committee. If substantiated, the allegations could result in partnership termination and bar discipline proceedings. My phone buzzed. Text message from Heath Jefferson, our document review manager. Saw the alert. We need to talk tomorrow. This looks serious. Heath had been with the firm for 6 years. He'd started as a contract attorney and worked his way up to managing our entire document review operation. I'd supported his promotion to department head last year when other partners questioned his qualifications. He'd seemed grateful for my advocacy. I opened the partnership agreement on my laptop. Section 12 outlined procedures for ethics violations. Any partner could file a complaint triggering immediate investigation. The accused partner was suspended from new client matters pending resolution. Partnership voting rights were temporarily revoked. The timing was deliberate. Tomorrow morning, we were scheduled to vote on the firm's largest acquisition in 5 years. Merging with Piedmont Legal Group would double our size and establish satellite offices in Charlotte and Greensboro. I'd been leading the due diligence committee and planned to recommend approval. Without my vote, the acquisition could fail. I checked the system logs again. The administrative access had lasted 47 minutes, enough time to create false billing entries and generate supporting documentation. The perpetrator knew our case management software intimately and understood partnership procedures. This wasn't random. Someone wanted me neutralized before tomorrow's vote. My office door was locked. The hallway was empty. Security cameras would show who'd been in the building tonight, but accessing that footage would require involving building management. That meant creating a paper trail and potentially alerting other partners before I understood what was happening. I printed the billing alert and supporting documents. They looked convincing. Detailed time entries, client matter numbers, even my electronic signature on the submissions. If I hadn't known better, I might have believed the allegations myself. The partnership meeting was scheduled for 9 a.m. 7 hours to figure out who was trying to destroy my career and why. The investigation began at my kitchen table at 5:30 a.m. Coffee steamed beside 3 stacks of documents: the fraudulent billing records, legitimate case files, and partnership agreements. I'd learned to compartmentalize during my prosecutor days. Organization revealed patterns. Heath Jefferson had joined our firm during the expansion phase 2 years ago. We'd been hemorrhaging money on temporary document reviewers for 3 major litigation cases. The partners were desperate for someone who could streamline the process and reduce costs. Heath's resume showed experience at 2 other firms and glowing recommendations. I'd interviewed him personally. He'd impressed me with his knowledge of litigation support software and cost reduction strategies. When he proposed creating an in-house document review department, I'd backed the initiative in partnership meetings. The other partners had been skeptical about the upfront investment, but I'd argued it would pay dividends within 18 months. The numbers proved me right. Heath's department had saved the firm over $200,000 in the first year alone. His team processed discovery documents faster than any outside vendor we'd used. Client satisfaction scores improved. The partners who'd initially opposed the hire began praising my judgment. I'd backed their decisions in every partnership dispute. Heath had requested additional software licenses last month. He'd explained that new litigation support tools would increase efficiency by 30%. The cost was significant, $45,000, but the projected savings justified the expense. I'd signed the purchase authorization without hesitation. Now I wondered what those software licenses actually did. The billing system showed the fraudulent entries had been created using my login credentials, but the timestamps revealed something interesting. The entries were made at 11:47 p.m. on Tuesday. I'd been at home watching the Hurricanes game with my neighbor. My laptop had been locked in my office desk drawer. Someone had either stolen my password or found another way to access my account. I opened my laptop and checked the case management system's audit trail. Every action was logged with user credentials and timestamps. The fraudulent billing entries appeared under my username, but other activity that night showed a different pattern. At 11:30 p.m., someone had accessed the client database using Heath's credentials. They'd pulled files for 3 major cases I was handling. 15 minutes later, my credentials were used to create the false billing entries. Then Heath's credentials were used again to generate the supporting documentation. The sequence was too convenient. Either Heath was incredibly careless about covering his tracks, or someone wanted me to discover his involvement. I called the office security company. The automated system required a PIN to access building entry logs. I'd never used the service before, but my name was listed as an authorized contact. The PIN was probably my employee number. It worked. The system showed 3 people had entered the building after hours on Tuesday night. Heath had badged in at 11:15 p.m. 2 other entries belonged to the cleaning crew, who'd arrived at their scheduled time of midnight. Heath had left at 12:34 a.m., 79 minutes in the building. More than enough time to execute his plan. But something felt wrong. Heath was methodical and careful. He wouldn't leave such an obvious trail unless he wanted to be caught, or unless someone else was setting him up. I drove to the office at 7 a.m. The parking lot was empty, except for the security guard's car. My keycard opened the main entrance, and I took the elevator to the 4th floor where Heath's department was located. The document review center occupied half the floor. 20 workstations arranged in rows, each equipped with dual monitors and specialized software for processing legal documents. Heath's office was in the corner, with glass walls that allowed him to supervise his team. His door was unlocked. The office was neat and organized, exactly as I'd expected. But his computer was still logged in, displaying the case management system's main dashboard. Heath never left his workstation unsecured. It was one of the security protocols he'd implemented when he took over the department. I checked his browser history. The last accessed page was the partnership agreement section dealing with ethics violations. The timestamp showed Tuesday night at 11:51 p.m., 4 minutes after the fraudulent billing entries were created using my credentials. A folder labeled Acquisition Analysis sat on his desk. Inside were financial projections for the Piedmont Legal Group merger, including detailed breakdowns of how the combined firm would be structured. The documents showed which partners would retain voting rights and which would be relegated to non-equity positions. My name was highlighted in yellow on the organizational chart. Under the proposed structure, I'd lose my equity stake and become a senior associate. The notation in the margin read, Ethics Violation, Partnership Review Pending. The analysis was dated 3 weeks ago. Someone had been planning this for almost a month. I photographed the documents with my phone and returned the folder to its original position. The decree was circumstantial, but it painted a clear picture. Heath had been working with someone to sabotage my position before the merger vote. The question was, who else was involved? My phone buzzed with a text message from Beatrice Jefferson, the firm's managing partner. Emergency partnership meeting moved to 8 a.m. Please confirm attendance. 45 minutes earlier than scheduled. They were accelerating the timeline. I locked Heath's office and returned to my car. The pieces were falling into place, but I still didn't understand the complete picture. Heath was the document review manager, not a partner. He couldn't benefit directly from my removal unless someone had promised him something in return. The Piedmont merger would create new opportunities for advancement. Department heads could become partners in the expanded firm. Heath's position would be elevated significantly if he played his cards right. But he'd need an ally among the existing partners to make that happen. I parked outside the office building and reviewed my notes. They pointed to Heath, but the sophistication of the scheme suggested he wasn't working alone. Someone with intimate knowledge of partnership procedures had guided him through the process. Someone who understood exactly how to neutralize me before the crucial vote. At 7:50 a.m., I walked into the conference room where 5 partners were already seated. Beatrice Jefferson sat at the head of the table, her expression unreadable. The others avoided eye contact. Heath Jefferson stood in the corner, holding a manila folder. He looked directly at me and smiled. "Alexander, please take a seat," Beatrice Jefferson said. Her voice carried the formal tone reserved for disciplinary proceedings. I remained standing. "I'd prefer to address the allegations directly." Heath Jefferson stepped, opening his manila folder. "This speaks for itself. Client billing irregularities spanning 18 months. Unauthorized case settlements. Misappropriation of discovery materials." "Those are serious accusations," I said. "I assume you have documentation." He handed me a stack of papers. The top sheet showed billing entries from my cases, but the timestamps had been altered. Settlement agreements bore my electronic signature on dates I'd been in court on other matters. Discovery logs showed materials checked out under my access code during vacation weeks. "This is fabricated," I said. "The case management system doesn't lie," Heath replied. "Every transaction is logged with biometric verification." Beatrice leaned. "Alexander, these records show a pattern of ethical violations that could expose the firm to malpractice claims and bar sanctions." I set the papers on the table. "Check the server logs against the courthouse calendar. Cross-reference the settlement dates with my court appearances. The timeline doesn't match." "We've already conducted that analysis," Heath said. "The discrepancies are explained by remote access and after-hours work, which I can prove I didn't perform." "How?" I pulled out my phone and opened the parking garage app. "Electronic records from the building's security system. My keycard shows no after-hours access during the dates in question. The garage cameras will confirm my vehicle wasn't here." Heath's confidence wavered slightly. "Remote access doesn't require physical presence." "True, but the firm's VPN logs will show no connections from my home IP address during those times." I looked at each partner in turn. Unless someone cloned my access credentials. The room fell silent. Beatrice made a note on her legal pad. "There's another issue," I continued. "The Piedmont merger vote is scheduled for next week. The timing of these allegations is convenient for anyone who wants to alter the partnership structure before the acquisition." "That's a serious accusation," said one of the other partners. "It's a factual observation. Heath stands to benefit significantly from my removal. His position would be elevated in the merged firm." Heath's face flushed. "This isn't about the merger. It's about protecting our clients and maintaining ethical standards." "Then you won't object to a forensic audit of the case management system?" "Of course not." I turned to Beatrice. "I request an independent investigation before any partnership decisions are made. The Professional Licensing Review Board should examine these allegations." "That seems premature," Heath interjected. "Does it? If he is as clear as you claim, an investigation will vindicate your findings. If it's not, we'll discover who actually committed these violations." Beatrice closed her folder. "I'll contact Chief Disciplinary Counsel Robert Williams this morning. Until the investigation is complete, all partnership votes are suspended." Heath's expression darkened. The merger timeline doesn't allow for delays. The merger timeline is less important than our professional integrity, Beatrice replied. The meeting adjourned without resolution. As the partners filed out, Heath approached me. "You're making a mistake," he said quietly. "Am I?" "The current is overwhelming. Fighting this will only make things worse." "For whom?" He didn't answer. 3 days later, Chief Disciplinary Counsel Robert Williams arrived with a team of forensic accountants and IT specialists. They spent 2 weeks examining every case file, billing record, and system log from the past 2 years. The results were damning, but not for me. The investigation revealed sophisticated manipulation of the case management database. Someone had used administrative privileges to alter timestamps, forge electronic signatures, and create false billing entries. The modifications were traced to Heath's user account, but the access logs showed the changes were made during hours when Heath was supposedly off-site. Further analysis revealed the use of a cloned access token that replicated my credentials while maintaining Heath's administrative permissions. The scheme was designed to frame me while protecting the actual perpetrator. But Heath had made one crucial error. The cloned token contained metadata that identified the source computer used to create it. That computer belonged to Heath Jefferson, and the creation timestamp coincided with his documented presence in the office. When confronted with this, Heath initially denied involvement. But the digital trail was irrefutable. Security cameras showed him accessing the server room during off hours. His personal laptop contained forensic of the cloning software. The investigation also revealed Heath's financial motive. He'd been promised a partnership position in the merged firm in exchange for eliminating me as a competitor. The promise came from someone at Piedmont who wanted to reduce the number of existing partners in the acquisition. Heath had been manipulated as much as he'd tried to manipulate me. Chief Disciplinary Counsel Williams recommended immediate suspension of Heath's law license pending criminal charges. The state bar filed formal complaints for fraud, forgery, and professional misconduct. Heath was arrested on a Thursday morning as he arrived at the office. The charges included computer fraud, identity theft, and conspiracy to commit wire fraud. His bond was set at $50,000. The Piedmont merger was postponed indefinitely. The acquiring firm withdrew their offer after learning about the internal fraud investigation. Our partnership structure remained unchanged, but the trust between partners had been permanently damaged. I spent the following months helping other attorneys who'd been targeted by similar schemes. The case became a cautionary tale about the vulnerability of digital legal systems and the importance of independent verification. Heath Jefferson pleaded guilty to all charges 6 months later. He received 2 years in federal prison and permanent disbarment. The judge noted that his actions had undermined public confidence in the legal profession. The firm survived, but barely. We lost several major clients who questioned our internal controls. 3 partners left to start their own practice. The remaining partners implemented new security protocols and oversight procedures. Justice had been served, but the cost was higher than anyone anticipated. 12 months later, I stood in my new office overlooking downtown Durham. The view was different, but the work felt familiar again. I'd joined a boutique litigation firm specializing in white-collar defense. The irony wasn't lost on me. My new partners, Beatrice Morrison and Heath Richardson, had recruited me specifically because of my experience with internal fraud cases. They wanted someone who understood how quickly trust could dissolve and how carefully it needed to be rebuilt. The transition hadn't been seamless. Leaving Raleigh meant starting over with new clients, new procedures, new relationships. But it also meant escaping the constant reminders of what Heath Jefferson had done to our partnership. I kept my Raleigh condo but rarely visited. The city held too many memories of late nights spent questioning every document, every conversation, every decision I'd made during those final months at the firm. The old partnership had officially dissolved in September. The remaining partners couldn't agree on new leadership or security protocols. Each went their separate ways, taking their client relationships with them. The office space was converted into a medical practice. I'd testified in 3 similar cases since leaving. Other attorneys had discovered comparable schemes at their firms. The legal community was slowly recognizing how vulnerable our digital systems had become to internal manipulation. The North Carolina State Bar had asked me to serve on a new technology ethics committee. We were drafting guidelines for law firm cybersecurity and internal controls. The work felt important, even if it came too late for my old partnership. I co-authored a law school textbook on attorney misconduct. The publisher wanted real-world examples of how trust breaks down in professional relationships. Heath's case provided the perfect cautionary tale. My new practice focused on defending attorneys accused of professional misconduct. Most cases involved misunderstandings or minor violations, but occasionally I encountered situations that reminded me of my own experience. The work required careful attention to detail and an understanding of how quickly reputations could be destroyed. Beatrice Morrison had been particularly supportive during my transition. She understood the psychological impact of professional betrayal. Her previous firm had experienced a similar situation involving embezzled client funds. The Durham office felt safer somehow. Smaller staff, tighter controls, more personal relationships. We knew each other's work habits, vacation schedules, and family situations. Trust was earned gradually through consistent behavior, rather than assumed through partnership agreements. I still checked my case management system obsessively. Every billing entry, every document timestamp, every access log. The paranoia had become a professional asset rather than a personal burden. Heath Jefferson had been released after serving 18 months. His disbarment was permanent, but he'd found work as a paralegal in Charlotte. We'd never spoken since his arrest, and I had no intention of changing that. The financial recovery had taken longer than expected. Insurance covered some of the losses, but the reputational damage couldn't be quantified or reimbursed. Several former clients had filed malpractice claims that were still pending. My new partners understood why I insisted on redundant security measures and independent verification procedures. They'd implemented similar protocols after their own experiences with internal fraud. We shared a healthy skepticism about digital systems and human nature. The work in Durham was challenging but rewarding. Corporate clients appreciated my attention to detail and understanding of internal controls. I'd developed a reputation for thorough preparation and careful documentation. Evening walks through downtown Durham had replaced my old routine of late-night document reviews. The city was quieter than Raleigh, more manageable. I'd found a rhythm that didn't require constant vigilance. The textbook had been well received by legal educators. Several law schools were incorporating our case study into their professional responsibility courses. Future attorneys would learn about the importance of verification and the dangers of blind trust. I'd kept one memento from the old firm, a framed photo of our partnership retreat from 2 years ago. Heath Jefferson stood in the back row, smiling confidently. The image served as a daily reminder that appearances could be deceiving and trust required constant maintenance. The sun was setting over Durham as I finished reviewing the day's case files. Everything was properly documented, independently verified, and securely stored. The protocols that had once felt excessive now felt essential. My phone buzzed with a text from Beatrice Morrison about tomorrow's client meeting. The message was brief, professional, and exactly what I expected. No hidden meanings, no ulterior motives, no reason for suspicion. I locked the office door and walked to my car. The parking garage was well lit and monitored by security cameras. Small details that I noticed now but had once taken for granted. The drive home took 15 minutes through familiar streets. I'd learned the routes, the traffic patterns, the safe places to stop. Durham was becoming home in ways that Raleigh never quite had. It was finally over, and the silence felt earned.